with the intent of discouraging an elector to vote for a particular candidate, or a call that misdirected the elector on that day, on election day or before election day, so that they actually wouldn't vote. So one type of voter suppression activity or the other, the kinds of activities that are have now been reported in the media for the last month. So that was the focus of the questions we put to people.
All have misdirection as a common theme. There could be some sort of harassment as well.
I'll turn it over to Gary.
I believe all the applicants received calls misdirecting them. We will have some additional evidence in some of the ridings that alleges the harassing phone calls technique. For example, one voter that I spoke with, a mother of a very young child, who had indicated she would not be supporting the Conservative Party, received calls allegedly from the local Liberal candidate as early as 6 a.m. on a Sunday and as late as 11:30 p.m. on a weeknight. And she received about 15 of these over the course of the last few weeks of the campaign. She got so angry she called the local Liberal candidate, and their office assured her that no such calls were being made. So some of the affidavit evidence we will have, I think, will cover some of the other techniques, but each of the applicants received one of the misdirection calls.
Question for the lawyer. The law says that you have 30 days to file such an application after the official results are published in the Gazette, or 30 days after finding that there might be some problems. So I was wondering, what exactly is that date that you consider your clients being notified of some problems? Is that the post-media news story? And if so, that was the 23rd of February, so the 30 days is expired.
Well, I think if you count from the 23rd of February, probably the date was Monday in terms of, because I think the 30 days probably fell on a weekend. But in each of our cases, the applicant indicates when they became aware that this was a broader problem, that whatever they had experienced during the election campaign of May 2011 suddenly was cast in an entirely new light. And that was all late February or early March, and I'm sure there may be the argument that we're too early, that we should be waiting for the outcome of the Elections Canada investigation. But if an election result is fraudulently obtained, it's not much of a remedy to have a judge in all the elections a year before the next election. If this remedy is going to have any utility, it has to be provided reasonably quickly.
Out one of these applications. I assume there are 6 others.
That's correct.
And why? I guess I can understand why, in the case of Nipissing to Miskaming, that Jay Aspin is a respondent. Why is Anthony Rota a respondent? Why isn't he on the other side of the
all of the respondents are identified by the statute itself to include all of the candidates in the riding.
Can you provide all the other applications as well?
Yes, I think we can. We wanted to. We have this one because Peggy happens to be here today, and we wanted to give the candidates the benefit of seeing them before we made them public, and we're in the process of doing that. But they'll all be available very shortly.
Do you actually have to prove who is responsible of the misbehavior, or do you just have to prove that they actually happened, whoever is responsible for it?
It's the former, and that's the difference between what this is about and what Elections Canada is doing.
It's a ladder.
Well, no, oh, I thought you said, well, we don't have to.
Okay. The full sentence. And therefore I can quote you.
We don't have to.
Your
we don't have to show who is responsible. We just have to demonstrate what it was that happened. And from a legal point of view, we're indifferent as to the culprit. What matters is that people's democratic franchise may have been taken from them, and they have the right to have it restored, whoever took it from them.
Which raises the question whether you have anyone who, you mentioned, I think, somebody somewhere, I'm not sure where, who actually did not vote as a result. But a lot of these people, they weren't fooled, right? So, I mean, how do you say that their right was taken from them if they actually didn't vote as they wished?
Well, we have expert evidence on the impact of voter suppression techniques and what that means in terms of whether people turn up at the poll or not. So we'll rely on that expert evidence, because in a riding where there's a margin of 300 or 800, we're not going to be able to find 800 people, and probably they're going to be pretty reluctant to come forward and say, well, I was fooled and deceived and didn't vote as a result. So there has to be another way for the court to kind of weigh the evidence that will give a judge confidence that they can go from this evidence about voter suppression activity in the riding to an informed estimate of what impact that would have had on the turnout.
I believe there was a reference made to 1988. There was a federal election result that was overturned. I think that's the last time there was one. So is this then new territory? You're actually having to plead voter suppression? You're having to prove something for the first time to Elections Canada?
This is a case unlike any other that we've been able to find reported in the jurisprudence.
Specify if there was a case in the past where an election result was nullified?
There have been cases, and they were of a different character, people ending up on the wrong list and more technical problems, not cases involving a deliberate effort to mislead electors during a campaign to not vote for a particular candidate or to not vote at all. This is uncharted terrain in terms of the law and jurisprudence on the subject of the Elections Canada Act. And the democratic right that people enjoy is a fundamental constitutional guarantee in Canada. Right? The right to vote is set out, and the protection of the right to vote is Section 3 in the Charter of Rights and Freedoms. This is a very fundamental democratic right, and it hasn't been challenged in this way in any of the jurisprudence under the Elections Canada Act before.
Then is very different than what Elections Canada is trying to prove. Elections Canada is trying to prove malfeasance. You're trying to prove suppression.
Exactly, and the consequences and the results are very different. Elections Canada may find guilty actors and prosecute them. This is about restoring the democratic franchise that people may have had taken from them.
Federal government, the federal court might just say, look, we cannot, the expert evidence you have is maybe American evidence, or it's something that's not been sustained in any Canadian context where you don't really feel qualified to judge on voter suppression.
Well, it's uncharted terrain, so it's always perilous to try to predict how a court will actually deal with these issues. But they're obviously very serious. They'll be taken seriously by the court. We're quite certain of that.
Researchers who've looked into certain of these writings where the calls take place have noted possible targeting of certain demographics, specifically senior citizens in some case, and families of new Canadians. In your respondents, did you notice any such focus on specific demographics, or did you find that it covered the full spectrum of Canadian voters?
I don't know with respect to the 9 applicants we have what the demographic profile is, but I do know in the phoning that I made personally, there tended to be an older demographic that had been targeted and was concerned about it. But I'm not sure of the 9 applicants.
When this may be, you said you filed the applications, you're going to ask the federal court to group them in one common cause, one common case. Any idea of the timelines that you're looking at?
Well, the court's directed to deal with these matters without delay, and that's clear from the statutory scheme of adjudication as well, because while this begins in the federal court, the next stop is with the Supreme Court of Canada, so you don't go to the Court of Appeal, which is an unusual process. And I think it speaks of Parliament's intent to have these issues resolved quickly, because, as I indicated earlier, if the remedy is to have any utility, it can't come 3 years later, 3 years after the election. So hopefully it'll be dealt with expeditiously by the courts. That will certainly be our request of the court.
So Walsh, did you hear of from any of your other friends of these allegedly fraudulent calls, or had any of your other friends or colleagues or neighbors received these calls? What?
In recent weeks, I have had a few people tell me that they too received the calls. They couldn't speak to exactly what had occurred, but there are other complaints. As I understand it, there are other complaints being made to Elections Canada in our riding.
Dozens of complaints?
Personally, I only know of maybe 5 others. Yeah, not too many.
You're already halfway, one-third of the way to overturning the result, aren't you? It was only 18 votes, wasn't it?
Yes.
Cost your organization to litigate all the way through?
Short answer is no. The longer answer is this is really a fundamental democratic principle. We are hopeful that Canadians will see it the way that we do, and that, in fact, we'll be able to raise all of the funds that we need to pursue this case as far as it has to go. We're actually quite optimistic. This will take the Council of Canadians beyond its normal base of supporters, which is large, 75,000, but we believe we'll attract others as well, because it is such a fundamental issue. I have no idea of the costs, and I doubt that Stephen would venture to.
The applicants. You mentioned that not all of your applicants have filed a complaint with Elections Canada. Did you encourage them to? Did some explain why they did or didn't?
Certainly everyone that I spoke with, I asked them if they had reported to Elections Canada, and if they had not, I suggested that they do that. And indeed, in our survey form itself, we indicated that people should report to Elections Canada. We support having an Elections Canada review and investigation, but they have a particular role to play, which is different than this court action. We also support public hearings into this, because, of course, Elections Canada is also limited, because they will be looking for criminal behavior, and of course the bar is set pretty high for criminal behavior. But a public inquiry in the end may be the only way to really get at who was behind the voter suppression techniques.
That you're going to get a political accusation. You're going to be accused of choosing 7 ridings in which, in every case, a Conservative won, and you're seeking to overturn the victory of a Conservative. So you're going to get the accusation, this looks like a left-leaning group that's going to bat against Conservative victories in ridings. How are you going to answer that?
The issue here is the rights of individual electors. The issue here is about fraudulent activity on a riding level, and the rights those electors have to seek to have their franchise reinstated. Now, if you ask me if I would be surprised if the road led at some level to the Conservative Party of Canada, I would answer no, I wouldn't be surprised, given the record of this government on issues like the prorogation of Parliament, on the advice to committee chairs about how to disrupt normal parliamentary routines, on the use of closure in Parliament. It wouldn't surprise me at all, but that's not the issue. The riding of Guelph, we looked at the riding of Guelph. We had people who came forward in the riding of Guelph, and we considered that. The problem there is 7,000 vote margin, when our academic evidence indicates that it can have roughly 3% impact. That's roughly 2,500 votes in a riding. So it would be pretty difficult for us, we think, to support an action in a riding where there was such a margin of victory, 7,000 votes.
No ridings in which there was a narrow margin of victory for a Liberal or an NDPer, and there were irregularities.
We received several calls, or we received and spoke with people in several ridings that had that profile. But in the final analysis, we had to make a judgment about what we thought was credible evidence from individuals, whether we have supporting evidence from that particular riding that will come forward, and that was the basis on which we made our decisions. It was really an honest assessment.
And you say we had to make an assessment of you were saying that it was
well, there were some, one person I spoke to said, well, I know this happened to me. Well, tell me more. Well, I'm not sure what day it was, and they said they were Elections Canada, but I suffer from migraine headaches, and we just had to make obviously some sort of assessment about who we thought were credible individuals coming forward with a story to tell, and that was part of what we did and followed up. And each of the applicants, each of the people who will be putting an affidavit in, a number of people have now spoken with them.
I believe, if I'm not mistaken, and you could correct me on this, that the academic evidence that you cite was rather comprehensively debunked by one statistician who suggested that drawing a correlation between ridings where there were robocalls and the amount of people who turned out to vote was a bit like drawing a correlation between ridings which had a lot of robocalls